All right, so everyone, I've been informed that there is a verdict. I understand that sometimes emotions run high in criminal cases, but whatever the verdict is, there's to be no outbursts. If there is, whether you are a witness or not, you will not be allowed back in this courtroom. Does everyone understand? And everyone needs to make sure that their phones are on silent. And state, if I could see y'all in defense, if you could come up. All right, ladies and gentlemen, it's the court's understanding that a verdict has been reached. Is that correct?
Yes.
All right, and is that verdict unanimous as to all counts?
Yes.
All right, if you'll hand the verdict form to the deputy, please. All right, it appears that the verdict form is in order. If the defendant will please rise. All right, count one reads, we the jury find the defendant Vernon Dixon guilty of the offense of murder as charged in count one of the indictment. Count two reads, we the jury find the defendant Vernon Dixon guilty of the offense of unlawful possession of a firearm as charged in count two of the indictment. Count three reads, we the jury find the defendant Vernon Dixon guilty of the offense of tampering with physical evidence as charged in count three of the indictment. You may be seated. Does anyone wish to have the jury polled?
Defense respectfully request to have the jury polled.
All right, thank you. All right, ladies and gentlemen, what I'm going to do, and I know we have alternates in the box, and the alternates were not a part of the deliberations. So jurors, I'm going to ask you if this is your verdict to each count. And if it is your verdict, if you would say yes. Is this your verdict?
Yes.
Is this your verdict?
Yes.
Is this your verdict?
Yes.
Is this your verdict? Is this your verdict?
Yes.
Is this your verdict?
Yes.
Is this your verdict? Is this your verdict?
Yes.
Is this your verdict? Is this your verdict?
Yes.
Is this your verdict?
Yes.
Is this your verdict? All right, thank you. So ladies and gentlemen, what we're going to do now is we're going to take a brief break and then we will bring you back in. So Deputy Mejia, if I could still have the alternates separated, please. All right, so with regards to phase two, defense and state, we had a discussion off the record. So I'm going to see about taking care of that. And if y'all could meet me in the back while I make those phone calls. All right, do you need to speak with Mr. Dixon now? All right. So everyone, we're going to go on a, all right, everyone, we're going to go on a brief recess while I take up one matter. And Mr. Del Corto, I promise we're going to get your matters solved. Anything else? Mr. Wolf, who are you here for? Okay. All right, ladies and gentlemen, this is the second phase of the trial. State, do you have any opening statements?
No, Your Honor, we'll waive the opening statement.
Defense?
The defense is fine waiving a statement, opening statement, Judge.
All right, state, do you have any evidence to present?
Yes, Your Honor. At this time, the state's going to offer State's Exhibit number 41. Is the waiver and stipulations concerning clause number 1993 CR 6163.
All right, if you could slow down just a little bit.
Sure, Judge. 1993 CR 6163 and 2006 CR 7214A. That's the defendant's waiver and stipulations concerning these.
All right, any objections to State's Exhibit number 41 that's been stipulated to?
No objections, Your Honor.
All right, then State's Exhibit number 41 is admitted into evidence without objection.
And Your Honor, permission to publish.
Granted.
And just very briefly, this is from the second page of the waiver and stipulations. It reads, I, Vernon King Dixon, do hereby judicially confess and admit that on the 13th of December, AD 1993, in cause number 1993 CR 6163, in Bexar County, Texas, the defendant Vernon Dixon was convicted of the felony of possession of cocaine under 28 grams. And after the conviction in cause number 1993 CR 6163 was final, the defendant Vernon Dixon committed the felony of possession of controlled substance, PD1, 4 grams to 200 grams, and was convicted on the 29th day of October, AD 2007, in cause number 2006 CR 7214A in Bexar County, Texas. It was signed by the defendant.
All right. And with regards to those stipulations, defense, I realize it's a stipulation, but for the record, to be clear, what was it your intention and your client's intention that those stipulations were in fact a plea of true to the enhancement allegations?
It was, Your Honor. The defense will stipulate as to the enhancement allegations presented, and it is our intention to plead true to those enhancement paragraphs.
All right. Thank you. State, any other evidence or witnesses?
No, Your Honor, the state will rest.
All right, defense.
Your Honor, the defense will rest. We just have argument.
All right, thank you. Do both sides close?
Yes, Your Honor.
The defense will close.
All right, ladies and gentlemen, I'm going to read to you what's the charge of court for punishment. Again, you do not have to memorize this. You'll be given it when you get ready to deliberate. Charge of the court on punishment. Members of the jury, the defendant, Vernon Dixon, has been found guilty of the offense of murder as charged in count 1 of the indictment, guilty of the offense of unlawful possession of a firearm as charged in count 2 of the indictment, and guilty of the offense of tampering with physical evidence as charged in count 3 of the indictment. The habitual offender enhancement allegation in the indictment alleges that before the commission of the offense alleged above, hereinafter styled the primary offense, on the 13th day of December, 1993, and cause number 1993 CR 6163 in Bexar County, Texas, the defendant was convicted of the felony of possession of cocaine under 28 grams. Before the commission of the primary offense and after the conviction and cause number 1993 CR 6163 was final, the defendant committed the felony of possession of a controlled substance, penalty group 1, 4 grams to 200 grams, and was convicted on the 29th day of October 2007 and cause number 2007 CR 7214A in Bexar County, Texas. To these above stated enhancement paragraphs and the habitual offender enhancement allegation in the indictment, the defendant has pleaded true. You will find the defendant has previously been finally convicted of at least 2 felony offenses as alleged in the habitual offender enhancement allegation in the indictment, and that the second previous felony conviction is for an offense that occurred subsequent to the first previous conviction having become final. You will so state in each of your verdicts that you will find true the habitual offender enhancement allegation in the indictment and assess the punishment of the defendant at confinement in the Texas Department of Criminal Justice Institutional Division for life or for any term of not more than 99 years or less than 25 years in each count. In this case, evidence has been admitted to the effect that the defendant may have committed an offense or offenses other than that for which you have convicted him. The court instructs you that you may consider this evidence, if any, in determining what sentence is appropriate in the case at hand, but you may only consider the evidence if you first believe beyond a reasonable doubt that the defendant committed this other offense or offenses. Our law provides the defendant may voluntarily absent himself from trial if he elects to do so. This, however, is a right accorded a defendant. And in the event he elects to absent himself, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected to be absent during this punishment phase of the trial. You are instructed that you cannot and must not refer or allude to the fact that throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that the defendant may testify in his own behalf if he chooses to do so, but if he elects not to do so, that fact cannot be taken by you as a circumstance against him, nor prejudice him in any way. The defendant has elected not to testify in this punishment phase of trial, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. In your deliberations, you may consider evidence introduced during the guilt phase of the trial, as well as any evidence introduced at the punishment phase of the trial. Under the instructions herein given, it will not be proper for you in determining the penalty to be assessed to be fixed the same by lot, chance, any system of averages, or any other method than by full, fair, and free exercise of the opinion of the individual jurors under the evidence admitted before you. The length of time for which a defendant is in prison may be reduced by the award of parole. With regards to count one, you are instructed as follows. The defendant will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed, or 30 years, whichever is less. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law might be applied to this defendant, because the application of that law will depend on decisions made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. With regard to counts 2 and count 3, you are instructed as follows. The defendant may earn early parole eligibility through the award of good time conduct. Prison authorities may award good conduct time to a prisoner who exhibits good behavior, diligence in carrying out prison work assignments, and attempts at rehabilitation. If a prisoner engages in misconduct, prison authorities may also take away all or part of any good conduct time earned by the prisoner. The defendant will not become eligible for parole until the actual time served plus any good conduct time earned equals 1/4 of the sentence imposed, or 15 years, whichever is less. Eligibility for parole does not guarantee that parole be granted. It cannot accurately be predicted how the parole law and good conduct time might be applied to this defendant, because the application of these laws will depend on decisions made by prison and parole authorities. You may consider the existence of the parole law and good conduct time. However, you are not to consider the extent to which good conduct time may be awarded to or forfeited by this particular defendant. You are not to consider the manner in which the parole law may be applied to this particular defendant. Suitable forms are attached hereto for your verdicts, if you should care to use the same. However, such forms are not intended to influence you in any way in arriving at your verdicts. In any event, each verdict must be unanimous in writing and signed by your presiding juror. Respectfully submitted, Judge Stephanie Boyd, 187th District Court, Bexar County, Texas, and suitable forms are attached. State, are you ready to proceed with closing?
Yes, Your Honor, we'll reserve all closing time.
All right, defense.
Thank you. Good afternoon, ladies and gentlemen. This will be the last time that I get to speak with y'all. And again, I want to start how we started this whole trial, and that is to thank y'all. Thank y'all for your time, your service, and ultimately your verdict. We respect your verdict, and ultimately it was your decision. Without you, this process just does not work. I want to just talk to you briefly. I'm not going to take much of your time. You heard the evidence, and I think you understand the punishment range that we're facing here. Minimum of 25 years, and that's where it begins. This is because there's 2 prior felony convictions, which we have stipulated to. However, take a look at the prior convictions. They're both drug offenses. This is the first violent offense that Mr. Dixon has been convicted of, and this was a violent offense. And we respect your verdict in that matter. I just want to give you a few things to think about and consider before you go back and deliberate, and the state will talk to you after me. Vernon is 57 years old. 57. That means if we assess even the minimum punishment, 25 years, which is on the murder charge, in the charge it tells you that it will have to be at least half time served, just 12.5 years. So you take somebody that's 57, they're looking at minimum 12.5 years. That puts them into their 70 years old. And parole is anything but a guarantee. Anything but a guarantee. This is nothing, it is far from guaranteed that the parole board may ever grant parole in anything. We ask you to consider that, consider the fact that we have a person that's 57 years old, not in particularly great health, and to consider what would be an appropriate sentence. I would suggest to you, and in fact, I would plead with you to please consider a punishment on the lower end of the range. Again, this isn't a 5 to life offense like it would normally be if there weren't for 2 prior convictions. This starts at 25 years, a minimum. If you feel the minimum's appropriate, we would certainly be appreciative. But I would suggest to you that even with a minimum sentence on this case, there's a very good chance that Mr. Dixon, quite frankly, will be dead in prison before he's ever given a chance or eligibility for parole. Ladies and gentlemen, thank you again for your time, your patience, consideration of this last week or so. I sincerely mean it. I know the state's going to talk to you, and ultimately, we'll thank you again for your verdict and decision on this punishment phase. Thank you all very much.
State.
Yes, Your Honor. Ladies and gentlemen, I'll be the last person to speak with you. And I do respect your verdict, and I do appreciate your deliberations and your time that you've spent here for the last, I guess, roughly week or a little bit longer than a week. This is the last hours, or at least the last day, hopefully, that you will have to sit here and deliberate on somebody else's future and their liberty. But I just want to go over a few things with you. Is that you came back with guilty on each count. And for Vernon Dixon shooting Avante Boyce. Again, the range of punishment is a minimum of 25 years to 99 years or life on each count. And I'm going to tell you, these sentences are all going to run concurrent. Nobody's spoken to you about that. They're what we call stacked is not going to happen in this case. That means that they will run at the same time. So if you give life on count 1 and they give 50 years on count 2 and then 40 years on count 3, all those run concurrent. That means they each start ticking away the years as soon as he gets sentenced and sent away. So really, the one on the left and the one on the right are the same thing. Count 1, count 2, count 3, life. I'm going to tell you this. We're asking for life because of the egregiousness of this type of crime. Because remember, in the end, he committed this on what he considered his own family, his son-in-law, in front of children. You remember the scene that the defendant fled from the scene. He fled off to Kansas. The defendant was running away from his responsibilities. His responsibilities, if you look at this scene with the children all over the crime scene, you see the yellow circle there. Those kids were coming home from school. If you look at the next moments before the shooting, there was children all over that scene. One in the car, which is Avante Jr. Another, Juju, which is on the right, sitting underneath that pavilion. Then the individuals getting out of the car coming back from school. During the shooting, Avante Jr. is in that car. Evie's in that car pregnant with his brother and Avante's unborn son. After the shooting, Evie's standing there with Avante Jr. After the shooting, she's walking out with her child in her hands, Avante's son. The witnesses, we want to keep our community safe. Think of Juicy, how scared he was. Yeah, he wasn't being cooperative, and maybe he's a homeboy of the defendant, but he wasn't talking for a reason, because that's a future danger, because he's going to be at fault, even though he didn't say everything that he should have said. Carl, independent witness, future danger, future harm. Evie, he shot her husband. Monique, which is his biological daughter. Donald, which is his son-in-law. Another son-in-law. Safety for the witnesses. The puzzle piece will show that this defendant is a future danger. Future danger to the children, future danger to the witnesses, to his own family, and to our community, the public in general. Let's seek justice for Avante Boyce's children. They won't be growing up with their father. Let's seek justice for a senseless murder, one of the most senseless murders that you probably will ever see, because somebody got upset, stepped out of a car when he had a choice to leave that scene, but instead he could have shot that gun up in the air. He could have shot the car. He could have shot the dumpster. He could have shot anything. But he chose to aim it at another human being, which he considered family, and killed him. We're asking for a verdict of life on each count for the justice of Avante Boyce in this case. I do appreciate your time. I will tell you this, is that like the judge said, and what Adam LaHood said, defense counsel, that parole is a possibility in this case. He will be paroled at some point, possibly. But if you assess life, the community, this family, these witnesses, those children won't have to fear Vernon Dixon anymore. So I ask from you as a jury, life imprisonment. Thank you.
All right, ladies and gentlemen, I will send you back. Again, the two alternates, you will be placed in a separate room. So if you need to remove your personal items from the room while you wait in the separate room, Deputy Mejia will take care of that. All right, ladies and gentlemen, it's the court's understanding that you have reached a unanimous verdict in this phase of the trial. Is that correct?
Yes.
All right, if you'll hand the verdict form to Deputy Mejia, please. Thank you. All right, the verdict form appears to be in proper order. To count one, it states that the jury is finding the habitual offender enhancement allegation to be true. They're assessing punishment at life. To count two, it states that the jury is finding the habitual offender enhancement allegation true. They're assessing punishment at 60 years in the prison. To count three, the jury is finding the habitual offender enhancement allegation true, and they're assessing the punishment to be at 60 years in the prison. Is there any request from either side to have the jury polled with regards to punishment? State? Defense?
No, Your Honor.
All right, ladies and gentlemen, this is the end of your service, but I'm going to have you all wait for me in the jury room and I come and speak with you briefly. And Deputy Mejia, the jurors who were separated can be reacquainted with all the jurors. All right, everyone, please rise for the jurors. Defense, what we will do then, if there are no objections from either side, the court reporter, myself, the state's attorney, and the defense attorneys, we will go into the back and I will pronounce sentence to your client. If y'all can make sure that he's done the trial court certification of defendant's rights to appeal.
Yes, Your Honor.
All right.
The judge, the state would be asking for a victim impact by the family of the victim of Avante Boyce.
All right. So the victim impact can be done. However, for security reasons, it's probably best that Mr. Dixon is not brought out, but they are more than welcome to get a victim impact statement.
Okay.
Okay.
I wrote this statement to let everyone know how the murder of my nephew has affected me and our family. He was 19 years old when his life was taken. Avante was a bright, kind, and loving young man who had a bright future ahead of him. Avante was always full of energy and laughter, and his smile lit up every room that he walked into. He was my sister's only son. He was my niece's only brother. He was the father of two beautiful boys, one on the way and the other one who he kept to him by his side. Since Avante's death, our family has been living a perpetual nightmare. My sister has trouble sleeping, eating, concentrating, and just getting along with the mundane task of everyday living. We all have nightmares and flashbacks of the day we went to the hospital to find out he was murdered. I walked into the room where he was being kept. I saw the tubes. I saw the blood stains. I saw the little boy who used to crawl into my lap and give me his toothy smile. But his smile was not there. It was gone. All our smiles have been gone since that day. My sister and my brother, Avante's mother and father, have been dealing with depression and post-traumatic stress disorder since this murder. She has been seeing a therapist to cope with her grief and trauma, but how can you alleviate that kind of pain? How can you fill a hole that can never be filled again? My family's lives have been shattered by this devastating loss. None of us will ever be the same. We will never see Avante smile again. We'll never hear his laughter again. We will never see him realize his promise or God's given purpose. Avante will always be in our hearts and our memories, and I love Avante. And this court has brought justice for our family, and I am so thankful for each and one of the jurors with their service. And I am so thankful and I appreciate you all working tirelessly. So that's all I want to say for now, because I'm getting a little bit of shakiness coming on. So that's all I want to say. Family, I love y'all, and justice has been served.
March 31st, 2022 is the worst day of my life. My heart was broken. Looked everywhere, still in the sky. I was still look for him. Yeah, hug you. Can't hear his voice. He won't come see me on my birthday, like he does. Someone decided that he didn't deserve to be here in the land of the living, to be a father, a brother, a son, an uncle, a nephew. Someone decided that for me and a whole lot of other people. Who gets to decide this?
I want to thank God for allowing me to make it to this point, the DA and his staff, SAPD for their hard work, the judge and the jury, my family for being here. On March 31st, 2022, you killed my only biological child, my son Avante Keyshawn Boyce. Then you ran like a coward. I tried my best to find you that night. I watched your whole entire family go in and out that apartment. I was waiting for you to come out. Then I remembered, revenge belongs to God. Not saying that if I had seen you, you'd be alive today, but for that one moment, God saved lives. Because of your cowardly act, you've torn down my family. You've caused a divide with lifelong relationships. But most of all, you left my 3 grandchildren without their father. You will never understand the pain of telling the mother of your child that he is no longer here, that he didn't make it, or having a mini stroke due to anxiety and stress, having to plan the funeral of a child that you asked God for. I never had to question God's will, but on that day you caused me to do so. I'm learning to forgive those who had anything to do with this. It's taking much prayer. I have to forgive in order to make it to heaven. But Vernon, Keno Dixon, if by chance I don't make it to heaven, I want to meet you in hell and beat and inflict 1,000 times the pain my son felt on that day. So for now, you owe me a life, yours. Just know that I'm watching, and know that if by any chance parole is an option, I will be at every parole hearing. I will see fit that there is no way you will see freedom in San Antonio ever again. I don't want any apology letters from you. I want you to find God. So when they ship your cold body home in a cardboard box, at least you would have done something for society by leaving it forever. During this process, I found who I am. I had to handle this with grace. I even asked my son's friends not to avenge his death because I knew God had this handled. I had to walk with my head up and chest out, and I will do the same after this is over. But as for you, no matter where you go, any prison you ship to, you'll be known as a kid killer. So in closing, I suggest these 2 words, find God. And in the words of our great judge behind us, request a therapeutic community because you need it.
That is a judge.
All right, thank you.